So let's go into the courtroom now. What the jury is listening to is the state's final rebuttal in front of them before the jury is going to get this case.
Way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who become a drug lord in Miami or whatever in the 1980s, and there's a scene in there where he gets caught, not for pushing drugs, but he gets caught for laundering money, like trading money for, the swapping it out with somebody else for, percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. And so he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not idiot. And the lawyer looks at him, and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey, baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Gamble's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things he created, and that's why, literally why, I ask you, so when you listen to this, nitpick, wait for an answer to this question. What do these things really have to do with the death of this child? And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay, and I'm sort of starting actually. I think I'm starting kind of in reverse. I should have gone back and put them in the order of the indictment, but there's a reason that I wanted to do them this way, and that is that I wanted to start with what's kind of the underlying felony charges, which then, go up the scale as you add other things. So aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body, which the evidence in this case establishes that J.D. Angeli's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice, or the word maliciously, and the law. And this is what I think Judge Southman was going to charge you to all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with you. And if you don't, if there becomes a question and you think, we need to be clear on this point of law, all you got to do is say, hey, Judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, whatever, with the degree of force that's necessary to fracture this bone, with the degree of force in a separate blow, with a degree of force that is sufficient to tear his liver practically in half, then folks, that's malice. Because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that it is a strong likelihood that pain is going to result. So if you find Trinity Poague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges, if you do, then that brings you to felony murder. And what felony murder is it says a person commits the crime of murder when in the commission of a felony he causes the death of another human being with or without malice. Okay? So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right this minute. Kind of thing. Don't have to prove that, okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony, was intentionally committed with the person knowing that it was likely to cause pain. And if you do, then that leads to the finding, I think, almost necessarily, I say I think and not I think, but I don't, there's, when you look at it, how do you analyze this? You find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here. And that circles back to where we were at the beginning of my first part, which is that the question is who caused the trauma that killed the baby within that time frame? I mean, that ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it, and he's absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. She had it when she came in this courtroom, okay? She has it when you go to the jury room, okay? But when you look at the evidence, and you find that the evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is not. It's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in Colquitt. J.D. was with him. He had been up here. He'd been up here earlier in the week. He'd stayed here like Thursday night, Friday night. Okay, he had stayed at her dorm or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay. She said because they're breaking up. She's breaking up, right? So she wants to leave. She wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies to
Louis Lamb there, the prosecutor. I mean, there's no lack of passion in this case.
No,
these jurors are getting everything from these two sides. We got to get to a break. When we come back, we'll have more of this rebuttal argument in the Trinity Poague's trial happening in the state of Georgia. Welcome back. We will get you back inside of that Georgia courtroom in just a moment, but first we do want to get you an update out of Massachusetts, the case that we are following very closely, the disappearance of Anna Walsh murder trial.
The defendant, Brian Walsh, is accused of killing and dismembering Anna back On New Year's Day in 2023, Walsh doesn't deny getting rid of her body, but claims that she died of something called sudden, unexplained death.
Now, in real time today, this jury has been hearing from a digital forensics examiner who testified that Walsh's suspicious Google searches didn't start to appear until after his wife's disappearance.
It's fair to say that in the searches running from the date of December 25th of 2022, up and including the end of December 31st of 2022, you saw no evidence of searches in the Safari search history regarding any searches for things like tools or searches suggesting how to dispose of a body or anything like that, correct?
I did not see any of those December 25th to the 29th.
Yes, but didn't he search about divorce prior?
Divorce attorney.
Yeah. Anyway, it's a fascinating case, and we're going to update you throughout the day, and we'll be heading there eventually, too. But right now, we want to finish up with the Trinity Poague case. Almost in the hands of the jury. It's the final leg of the trial, the all-important, and in this case, oh, they're good, the closing arguments.
Yeah, we're listening to Louis Lamb, the prosecutor there. He is giving his final closing argument. It's the rebuttal. This is all about this little baby that you see on your screen, J.D., an 18-month-old who was found unresponsive in the defendant's college dorm room and then later died at the hospital. The prosecution says she is the one that caused his injuries. The defense says no, it was her boyfriend.
Yeah, let's go back in the courtroom, pick up the state's rebuttal where we left off.
I just said I was in a wreck, and he told you that, of course, his reaction to that was he took off to the campus, to check on her, and she was in a wreck. She wanted to talk to him. And so it was sort of reverse stalking, like instead of following somebody, he said, here, come here and follow me. And that's exactly what she did. And so on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asked him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere is because he was going to be home with his son, with J.D., and nobody else was there. His sister wasn't there. He didn't have anybody else to keep. Didn't trust anybody else to keep J.D. And so he tells her, he says, I'll come, but I've got J.D. with me. And she says, well, come anyway. Just bring him with you. They get there, they eat dinner, they go to Sephora. She swaps the car seat from his car to her car because it says that according to his testimony, she says that it would maybe give her a little time to spend some time with J.D., while she's driving and work on building some kind of bridge or relationship with him, etc. So then she says she wants him to come back to Americus with her. And the car seat's in her car already, and he says, yeah, okay, I'll come back to Americus with you. Okay, so at this time, when they're in Albany, okay, this video is it's one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car, okay? This is when Jay Williams has left Colquitt and is coming to Albany, that this video is taken, okay? And he's wearing his little his black Nike is what I'm trying to say, his black Nike hoodie and not hoodie, jacket and pants, his suit, tracksuit or whatever, which is the same thing that Jay Williams was wearing himself. He made reference to it that was they had matching outfits. Okay, this is what this child looked like. Okay, there's no bruise on this side of his face. There's no marks on this side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now there are these claims that were made in opening statement, okay, that have turned out to just simply not be true. Okay, In opening statement, the defense says that Jay was drinking when he met her in Albany, and she just couldn't send J.D. back to Colquitt with him, so that's why she took the child, and then she let them come to Americus with her because they wanted, they wanted to go to Americus, or Jay did. That's what you were told you would hear. There's no evidence that says that. There's no witness who testifies to those things that you were told you would hear. In fact, what happens is on January 13th, if you look, after she has asked him to drive from Colquitt, from Albany to Americus, okay, before she's even back at the dorm, she texted Paris, and she says, "Are you coming back? I got stuck with J.D." Paris says, "Yeah, I'm coming back." And she says, he made me feel so bad because it's already late and J.D. is being so fussy. So he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense at all that he would have done that, because if he's in Albany, he'd be closer to home than he would be to here. So on on Saturday, then what happens is this. They get to the dorm, they go through the doors, and you saw the video from Georgia Southwestern. They go through the doors at 10:06. He testifies that he blows up the air mattress for Poague and J.D. to sleep on. Trinity Poague and the baby are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context of some of the other messages that we'll get to later, and I think the testimony of Paris in this trial suggested that typically when J.D. was here, that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit them. Okay. She wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender. He wasn't shy. Wasn't any of those things, okay, because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and think at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. J.D. isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with J.D.
Hitting the pause button on this rebuttal closing and bringing in criminal defense attorney Joseph Tully, who's watching along with us. I like, Joseph, how he is bringing up what the defense failed to show. Now, they don't have to prove anything, but they did make some promises in this case.
Exactly, yes. And so broken promises, empty promise from anybody, any side, in opening statement that doesn't bear truth throughout the trial is definitely used by the opponent in closing argument, and he's doing an excellent job at that. He's also taking the passion away from the case that the defense used in its closing statement, closing argument. He's going very clinically through a timeline and very methodically detailing how the defendant on trial here is the only, or is the most reasonable explanation, the only reasonable explanation for how these fatal injuries occurred.
Part of the promising in the opening Yeah, I think might have been related to a potential defendant on the stand scenario, because there are things that she would have been able to articulate. She decided not to take the stand. She doesn't have a great look, one could argue, in the courtroom. Those text messages are as horrible as you can get. She's a young woman. How do you navigate that decision, getting her up there to humanize her and just to say, I didn't do it?
It's really, really difficult. Most defense attorneys, most very, very good defense attorneys have a blanket rule of, I will not put my client on the stand. There's a level above that. It's very, very minority of defense attorneys that say, look, I will put my client on the stand. I don't know the situation here. A lot of times I think of the trial like a spotlight. When it's the burden is on the government, you have the spotlight on their side of the room. It's on the prosecutor the whole time. When you put your defendant, the accused, up on the stand, then the spotlight shifts to that person. And so it kind of shifts the burden. And that's why most people don't put the accused on the stand when in trial. Again, I don't do that as a rule. I like to put my client on the stand. What it tells me is that there was a lot of careful thought put into the decision. Then again, it could have been absolutely her decision. The defense attorney might have said, I want you to testify. And if she says no, you can't do anything about it.
Yeah, great spotlight analogy, Joseph. We've got to get to our break. When we come back, we are going to hear more of this rebuttal argument. The prosecution really kept their rebuttal to the lengthy part of their closing argument. Really short at the beginning, but of course, the actual spotlight on this victim, little J.D., 18 months old, did not deserve this. We'll see what happens in this trial. Coming up next.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
The massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
I'm Matt Johnson in Dedham, Massachusetts, covering the Brian Walsh murder trial. This is Court TV, your front row seat to justice.
Welcome back. We are continuing to monitor that trial out in Massachusetts for Brian Walsh, but now we're going back to Georgia. We're listening to these pivotal closing arguments in the pageant queen child murder trial for defendant Trinity Poague.
Yeah, the defendant here charged with murder and the death of her boyfriend's 18-month-old son, J.D. She faces up to life in prison if she is convicted.
Let's get you back in the courtroom, picking it up where we left off with the state's rebuttal close.
So it goes Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. JD she had gotten into bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and he put him on the bed with him and he laid him on his chest for a little while and whatever, and then they got up to take a shower. Now, the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower. The testimony, and you will recall it, of course, was that they talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later. And whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut. And at the time he left, and at the time Trinity Poague got out of the shower and went back in the room, JD was in that pink chair watching Katuri, a kids show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay? So when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry. That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said as he was parking, he was about to get out of the car, she calls back, and she's not talking to him. She hears him saying, JD, JD, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them back there. But if you should decide that you need to see them again, all you have to do is ask, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and frankly didn't testify real clearly as to what she said in response to that. We said what's wrong, but he wasn't waiting around to find out. He put the pizza in the bags down, put the pizza down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went in with JD. The nurse met him and put JD on a gurney, and then he followed them to a treatment room. Now, Alan testified. So there's this thing that Mr. Gamble keeps making a big deal out of. It says that this note in the nurse's record. He says this note says that the child is limp and pale, that father present at bedside states child fell around 5 minutes prior to arrival. Okay? And that note has a time, an event time of 12:36. Okay? So Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in. He was standing at the child's bed when he told them that. And folks, there's other things in this note that we know it's not exactly accurate. It's close, but it's not exactly accurate. Okay? The note says that the child is in ER, and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who was unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after when he came in the door, went to the front desk or whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that you've heard. He followed them to the treatment room, but Alan says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all of those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place that they'll let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay? By the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Bussman told you that. But he wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay? The note's written 8 hours later, and despite everyone's best efforts, okay, it's very hard to separate.
A really detailed rebuttal here from the prosecution. We've got to get to our break. When we come back, more of these closing arguments in the pageant queen murder trial. Plus, we'll get an update out of Massachusetts for the Brian Walsh trial. Stay with us. Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins. Thank you for following along with us as we track two major trials this afternoon here at Court TV. We are in Georgia. Closing arguments underway for a former pageant queen accused of killing her boyfriend's 18-month-old son in her dorm room. We'll get you back into that courtroom in just a minute.
But first, we want to check in on Massachusetts. Testimony continues for the husband accused of killing and dismembering his wife on New Year's Day back in 2023.
Yeah, Brian Walsh is the defendant here. He admits to getting rid of his wife's body, Anna Walsh, but says that she died from something like a sudden unexplained death and that he panicked. On the stand right now is Dr. Richard Atkinson. He's a forensic pathologist with the medical examiner's office. Let's listen in live.
Is that one of the pieces of carpet that you had the opportunity to examine?
Yes.
Your Honor, the Commonwealth would seek to enter into evidence PC 110195, image of carpet.
Any objection?
No.
That 110195 is now in evidence as 179, photo also of rug.
And may the Commonwealth publish, Your Honor?
You may.
Ms. Gilman, do we have 110195? So, doctor, is this one of the carpets that you had the opportunity to see that night or see that day when you were at OCME?
Yes.
And that ruler, did you place that there as well?
Yes.
All right, you can stream Walsh if you'd like, or just go to courttv.com. They'll get you there eventually. Right now, we're headed back to Georgia, though. We've got these two great cases, and these are the closing arguments. Last chance for both sides. We've already heard from the defense. Now, we're going back for more of the state's rebuttal closing argument.
The story of events that happened over the course of, just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in there 3 times that he said that. He didn't tell anybody anything 3 times, okay? The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note, okay? It's simply copied into the record because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and they get cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, that they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter, okay? And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital, and the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night. Alan wants to talk to him. Alan said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Alan asked him to go out and walked outside with him. And Alan asked him to go outside, and he does. He told Alan, according to Alan, he told Alan that Poague had told him that J.D. had fallen out of a chair. Poague got there, and she told Alan that J.D. had fallen out of a chair. She specified it was one of those round beanbag, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay, that's what she tells Alan, not what Williams tells Alan. I mean, it's the same thing Williams told him, but it's not. But it's not his words, it's her words. Okay. you know, there's a reality to what we do that when people go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line and word by word, second by second, minute by minute. Okay, I need you to tell me, what did you say and what did they say next? You know, and then we come into court and we have these, you know, these prior statements, and, you know, we've got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, you know, did you say that? Yeah, I said that. You know, I mean, and they know somebody knows they said it. They know they said it at some point back there. You know, if you ask me, you know, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say, yeah, that's what I told him too, you know, because it's kind of hard to delineate those things, and that's just the reality of the memory, okay? That's the reality of the memory, whether you're in a courtroom or, you know, you're sitting around, you know, on Christmas Eve with your family, and you start talking about something and say, you know, remember when so-and-so, and you realize that nobody there remembers it the same way you do, okay? And you end up, you know, like you have, you know, people just like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so, I mean, the reality is that the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Alan what Jay Williams testified to, okay? What Jay Williams testified to, which is different than what Alan testified to, no doubt, okay? What he says is that she was there and she told Alan in his presence, and that's where he heard the chair story from. In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who is promoting that story, not Alan. I'm sorry, not Jay Williams. I'll go ahead and address it now. I'll skip it later. He says, you know, but ask him, did you tell Samantha Ford that you knew, you know, did you tell her what happened? And he says, yeah, I told her. I told her what happened. I'm sure I told her what happened. And it's like, okay, well, what you know, what'd you tell her? You know, did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair. Because that's what he had told other people once he had heard it from her. But then he instead of getting the statement, the interview that that Ford had done with Jay Williams, okay, what Mr. Gamble does is instead of showing the interview and saying, look, you know, do you want to, you know, refresh your memory about this? Be sure that, you know, what you said. He doesn't do that. Okay? He's charging him with being able to have in his brain the knowledge of what he said in a 2-hour, I think it was an hour and 45-minute long interview on the day that his child died. Okay? So in 8 hours, in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the America's Police Department sitting in waiting rooms or interview rooms. He spends, he spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Ford. Okay, so you say, did you tell her that without showing him the interview, without showing him the statement, without letting him, look back over and say, well, I don't know what let me see exactly what I said in that 2-hour interview. And Mr. Williams says, yeah, I told her he fell out of the chair, because that's what he had been told, and that was the only information he had ever had about what happened to his child. He told Coroner Wright that Poague had told him that J.D. fell from a chair. But Poague also told Coroner Wright that J.D. fell out of the chair, that he was in a chair eating chips and he was in distress and fell from the chair. She told Wright that Jay had been gone for 5 to 10 minutes at the time the fall occurred. That is the sum and substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. Okay? The court is going to talk to you about circumstantial evidence. Okay? What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old and he's in a dorm room on the GSW campus and there's only one person in the room with him when it happens, you know, well, those are two direct facts, okay? Those are not circumstantial, those are two direct facts, and the circumstantial evidence is when you take those two direct facts and you make the inference, which is, under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay, and that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents, if it's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So you take those things into account, you think about it this way, you say, okay, now we know some facts, we know some direct facts. So what are the conclusions that can be reached from the direct facts? Well, I'd suggest to you that there's only two possibilities, okay? One is that it's accidental trauma, that's a possibility, or that it is inflicted trauma. Those are the only two possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not.
All right, the prosecution going all in as well on this case. A long rebuttal argument.
Yes. But that's a strategy, to put it all at the end rather than everything at the beginning and then a short rebuttal.
Fill up the jurors' minds with stuff so that they forget
They're
what
not
they
even
just
going to
heard.
remember at this point what the defense said, even though it was very passionate.
It was. Let's get a break. When we come back, we'll have more of that. Also watching Walsh, Busy Friday. Soon, this young woman's fate will be in the hands of a Georgia jury.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on Closing Arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
What do those messages say?
My mom is coming up here. Apparently, they plan on taking me down to the station. Later, an hour later, she says he has a skull fracture. Apparently, all of his friends and his sister think I did it. I didn't do it, Paris. I would never lay my hands on any kids.
That is the defendant, Trinity Poague's former roommate, reading out her text messages on the day that the victim in this case, an 18-month-old little boy, was rushed to the hospital and then died.
Pogue's text messages were the only words the jury was able to hear because she said she did not want to testify. We thought, just given the opening statements and the way things were progressing, that she would take that scary leap and take the stand, but she decided yesterday not to. So she's relying on her defense attorney, and her fate's going to be in the hands of this jury.
Yeah, will those text messages be enough for this jury to make a decision on what was in her mind at this time? Everything is winding down inside of that courtroom. We are still listening to the closing arguments. The prosecutor, Louis Lamb, he is laying it out in the final rebuttal in front of the jury before they get this case.
Accidental trauma. Talks about falling off the bed. The only evidence in this trial of a fall from a bed, okay, all of it, the whole total of all the evidence. Nobody was told by Trinity Poague at the hospital that fell off of a bed, that the baby fell off of a bed. Jay Williams wasn't told that he fell off of a bed. Okay? The police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said that he remembers, he said he didn't have a specific, he said he didn't know if there was a specific note, but he didn't remember for sure, you know, if she said chair or what, but something about a fall, and he says, all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, okay, that are recorded by somebody else, you know, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I can tell you that it changed significantly from the first time I talked to her, the second time I talked to her. Okay, so the only evidence of a fall off of a bed is this. I'm sorry. I think I skipped something here. But anyway, so you saw the message earlier, and I may have it out of order, and if I do, I'll apologize for that and try to do better next time. But you saw the text. You've heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says, he's okay, he's fine. Okay? So, not only does she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know. They won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know, I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed, I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell, that had to be it. And Trinity Poague's response is, but that was only off the air mattress, and the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and in the next two text messages concerning that matter, Trinity Poague says, I don't know if he fell off a bed because I was asleep. Oh, and he just fell off of an air mattress. Rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier, okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night, okay? At 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those two videos that this screenshot comes from, but it's from one of those two, either at 12:02 or 12:04. Okay, either no, maybe more than 10 minutes after the child fell off the bed, but it is 5+ minutes since she sent the text saying he fell off the bed. Okay, that is the state of J.D. Angeles. Okay, and you saw the video in court. That's the screenshot, of course. And you looked at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Oleg, okay, who's also not affiliated with the GBI or anyone else, I mean, other than her own practice, Dr. Oleg told you that there is zero possibility that following this injury, the child could be doing these very things. The nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gilbert says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now, he works for the GBI. You know, he works for the crime lab, which is true, he is technically an employee of the GBI. He says, you can't trust Dr. Clark. You know, because Dr. Clark's going to say whatever they want him to say, I guess, you know, is what he's implying. It's not the case. Okay? Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained, okay? And those, he doesn't get called to testify because nobody's being prosecuted for murder. Okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder. Okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case. Well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay? Issues a 6-page report, orders all kinds of stuff. Okay? Comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live, in person, with his hands and a scalpel, findings were that this child was murdered. So, of course, they're going to call him. So Mr. Gamble says, you know, he says, but Dr. Clark ain't as slick as he thought he was. He says, because I got him good now. I had this article. He got an article. Let me see if I can find the article. Was that up here?
I don't know that it is. I think they gave it back because we couldn't send it to the jury. I can give you a copy.
It's all right. Okay. This is the about the article. Dr. Clark said, well, give me a minute, let me read it. We took a little recess, okay? He read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off of an adult bed, died 2 days later of an epidural hemorrhage. You know, 9-month-old in, you know, Portland, you know, fell off of a table, you know, suffered injury, was taken to the hospital and they did not have any findings, died.
All right, a little long on the rebuttal, but passionate, bringing it. Both attorneys have another guy that does is Philip Dubé, and we go to him now in Los Angeles for his analysis of this case. It's down to the wire. Here we are. Overall thoughts, what stands out to you about the state's case, what they have and don't have going for them?
Well, I wish they would have had more defense forensics for Trinity, to be fair to her. And we've seen aspects of this years ago, Ted. I don't know if you remember covering a trial back in while I was in law school, okay? It was out here in California. It was Deborah Cummings. She was a daycare worker. I think she had 4 or 5 kids in her care, and of course she got a 9-month-old baby. It was from a interracial couple, and all of a sudden, the daycare mom calls the parents to say, you know, the baby's in distress. And of course, the baby died, and the coroner opined that it was due to shaken baby syndrome. But what the defense effectively did is during the autopsy, they took slides of the baby's brain to show that this phenomenon called fibroblast had been forming. And what it is, it's a form of healing connective tissue. And they can tell by the quantity of fibroblast in the connective tissue how old the injury was. And they were able to determine that the baby was not in her care at the time that the fibroblast started to form. So she was acquitted. And fast forward, we saw this with Louise Woodward, the British au pair. Remember that? Also I believe that was out of Boston, where she was convicted of second-degree murder based on a shaken baby syndrome type theory, but the court reduced it to involuntary manslaughter because they felt that she was just too confused and didn't have that mens rea, that intent to kill. So what do we have here? I'm not sure that what she did, if anything, rises to the level of malice aforethought, intent to kill, and I'm not sure that they have enough of the forensics to set her free to show that this was a pre-existing injury, that any touch or nudge to the child could have caused a rebleed and certainly all the symptoms associated with blunt force trauma to the baby. But I do like this prosecutor. I love the way he's superheated and waxing lyrical about the strength of his case, and I also appreciate the Melvin Belli aspect of defense counsel. We don't see those old school defense attorneys very often.
Wow, we can always count on Philip DeBay to have case elements, case law on these different cases. So we appreciate that.
He's our human AI here at court. You don't have to Google anything. You just talk to Philip, and he'll bring up case law and set things straight. It is a fascinating case. That's why our viewers are attracted to it. I mean, we have the Walsh case and this one, both fantastic cases. We'll see. It's getting down to that hour now. We'll get a break, and soon enough, the fate of this young woman will be in a Georgia jury's hands. We'll pick up the remaining last words from the state of Georgia coming up. Let's head back to Sumter County, Georgia for more of the closing arguments in the pageant queen child murder trial.
The defendant there, Trinity Poague. She was a former Georgia pageant queen. She's facing life in prison because prosecutors say that she killed her boyfriend's toddler son, this little baby you see there, an 18-month-old named J.D. His real name was Romeo Angelus, and his father didn't find that out until he died.
Yeah, he was found unresponsive in Trinity's dorm room. Later died at the hospital. She's being blamed for his death. Let's go back into the courtroom now. We're listening to the state's rebuttal case.
How do you make yourself believe it? How do you accept that Trinity Poague could do such a thing? Okay, yeah, so did she have a motive? She resented and ultimately despised that little boy, okay? Now, you know this from her statements, her text messages, etc., starting back in August of 2023. All right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone between her and Trinity Poague. They started the back and moved forward because because that's the way they're stacked up here. And she says, "I'm going to sleep in your room. I can't do J.D. crying that much. Hopefully he's in a better mood in the morning." Okay. Then she's talking about getting in the shower, and she puts him in there, wash him in the shower, and he gets water spraying in his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, "I'm trying to take a shower, and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him." Okay? I'm not going to baby a baby. If she was talking about Jay Williams, I'd say, yeah, I don't blame you, girl. I wouldn't baby him either, right? Grown person. She's talking about a little kid. She's talking about a kid that stands that tall, okay? That's unsteady on his feet still. And she said, "I'm not going to baby him." The witnesses that came and took the witness stand that were called by the defense said, "Oh yeah, she didn't like that young man. She didn't like him. She didn't like him." And not only that, he didn't like her. He didn't like her. She sends more messages in August 17th of 2023. She says, "Why do I feel anger towards J.D.? When we were laying in the bed and J.D. kept touching Jay's face, I almost cried." Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, what do you mean? Like you feel anger towards J.D.? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laughed my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love J.D. the same as mine, but since me and you have gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is, but just seeing him makes her angry. In December, she sends a message and says, yeah, I'm gonna come back to it. Let's go to January. The day before, the night before, was murdered. Says, what are y'all gonna do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that in fact that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the in the bathroom, and she didn't realize he was behind her. She opened the door or the drawer. I don't remember which one he said, but she opened it up and she hit him in the eye, hit him in the face. She said, I felt so bad. I felt so bad. Okay, where is JD when he gets the blow to the face? Okay, with Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know. I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified of her. You heard those people that said he cried and cried and cried when she was there, and he would stop crying if somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I'd submit to you that basically the same thing is true of an infant. Okay? You don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures,
Well, the prosecutor's there with that dramatic reading of the text messages. It's compelling to hear him and not an investigator reading those.
Yeah, and the old, the old dog thing, which we've all done. Like, my dog is a great judge of character, so if
this
he's
little
barking.
baby was always crying in her care, and she even knew that.
Yeah, I mean, it's not, there's nothing legal about it, but it's a great close to throw into someone's head.
It's all argument.
A juror.
It's not evidence.
Yeah.
Let's get to our break. When we come back, we will have more of this rebuttal. It should be wrapping up soon. And notice on your screen in real time, because we've been pausing things, the jury actually has this case now. 5 minutes. How long are they going to go? Deliberating the fate of Trinity Poague. Stay with us. You're watching Court TV.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8, 7 Central, only on Court TV.
All right, you see the clock ticking. The jury has the case against Trinity Poague. We're going to get the last bit of the final statements from the state, the rebuttal close. First, a quick check in Florida, though, where a child custody hearing took place earlier today for Anna Kepner's stepmother and her ex-husband.
Yeah, the stepmother, Chantel Kepner, she was married to Anna Kepner's biological father, Christopher, and they're in this dispute. She's in a dispute with her ex-husband over the custody of their 2 minor children. One of those children is the 16-year-old stepbrother of Anna, who is a suspect in her murder. That's according to reports.
Yeah, this, of course, is the cruise ship murder. And at that hearing, Chantel Kepner took the stand and spoke about the last time she saw her children before Anna's death on that ship.
At some point, did you discover that one of the children had passed away?
Yes.
And when was that you discovered that?
Friday morning.
Your child, did you see him that Thursday night as well?
Yes.
What time did you see him at?
Closer to 7. Just a little bit before 7.
And what was he doing at that time?
He was headed back to his room.
Do you know whether or not Connor was present in the room as well?
They all were headed back to their room, as far as I know.
All right, we'll have more of that coming up in the 2 o'clock hour, but right now, back to Georgia.
All right, those closing arguments that we've been watching in the pageant queen child murder trial for Trinity Poague. She was arrested last year after an 18-month-old, Romeo Angeles, was found unresponsive in her college dorm room, and she faces life in prison if she's convicted.
Let's go back to the courtroom now, the remainder of the state's rebuttal closing argument.
Okay, Jay Williams, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. You know, the world is looking at you, buddy. You know, Jay, I can't believe this. That baby is only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. You know, the drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, you know, I bet you he'd love to have to take one now. Bet you he'd love to have to take one now, you know? I mean, and if a trooper had seen him driving with a kid not restrained in a car seat or something, you know, and pulled him over, you know, he probably would have got a ticket for, like, reckless endangerment or something like that, and would have been prosecuted by whoever, you know, would have had jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, you know, I mean, it's my job to prosecute cases. It's his job to defend cases. You know, he's daggone good at it. And, you know, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things. And a law clerk and somebody from the clerk's office. And everybody's here for a reason. And, you know, I did this slide and I left off the judge. And it didn't sound like I'm being a smart aleck in doing it. But I was. I mean, I just inadvertently, I looked up and realized it's like, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job. Okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says, you will well and truly try this case and a just verdict give according to the evidence. Okay, there's 2 parts to that oath. There's 2 parts to that job. Part 1 is to well and truly try this case. And good Lord, I mean, y'all been great at it. I mean, everybody's been here every day, you know. I mean, people like, nobody's like, hey, look at that juror over there. They look like falling asleep, you know, things that we deal with, or, you know, waiting, you know, day after day for people who are invariably late and you know, don't come back from lunch and, you know, don't take notes, all those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath. And that is a true verdict give according to the evidence. Your job is to do justice for this baby. That is your job. To do justice. Do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the jury, you know, speak to the community. Okay? They speak. They say things to the community. People look at a jury verdict and they say, wow, you know, like, man, in America, they let people off for that. You know? But they look at jury verdicts and they say, you know, this is the wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of, like, not leaving blood, you know, kill somebody with your hands, you know, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verdict? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, you know. We're going to require video. We're going to require videos and confessions before we will convict. You know, if that's the standard you want to set, ladies and gentlemen, that's the standard you set. As DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. J.D. Angelus was 18 months old. If you want to do them right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. A true verdict given according to the evidence.
Move that aside.
Yes, sir.
Sorry.
All right, that's it. And as you see, the jury has it now 17 minutes. They've maybe picked a foreperson, just getting into the deliberations. Philip Dubé, overall thoughts on the case as this jury decides Trinity's fate.
Yeah, it's a rough fact pattern because when you think about it, I mean, here you have a 4.0 honors student studying nursing, I believe, which is a little weird. You would think that she would first do no harm, particularly with the baby. So it's kind of incongruous, the act, if you will, if she in fact did this to the baby, with her future goals and objectives and endeavors. I mean, she could literally, with the stroke of a pen by this jury, go from being a crowned beauty queen to a defrocked killer. It's really unbelievable. And if that's really the case, then this young lady has really two sides to her. But on balance, you know, it could go either way, frankly. And if she is convicted, I'm convinced it will be because of those sort of insensitive, if not offensive, text messages that she sent. It looks like that she had utter contempt for that baby. And I guess the jury would have to decide whether or not it would be a stretch to go from that contempt to a fatal blow to the baby's head.
Yeah, and even that fatal blow, even describing it, Philip, we don't really know what happened. Prosecution didn't really say exactly how she created those injuries. Real quick, before we have to go to break, was it a mistake for her not to get on the stand and give more of an explanation?
Yes. I think she should have looked her jury right in the eyes and said, I did not harm that baby. As soon as he left and the baby was there, something appeared to be wrong, and she did whatever she could based on the limited information that she had, and unfortunately, they're fingering her for this, but that she's innocent.
And now we will see what the jury does with it. Philip Dubé, thank you for your analysis.